Okay, now that we've got a handle on Lockean theory, right, the social compact, the idea of power that is ceded to the government, and the idea of power that is retained by the people, right, rights that are retained by the people. Now it's time to look at the 9th and 10th Amendment. So it was controversial whether we should have a Bill of Rights at all, but it was a compromise. It was really a political compromise that was reached during the founding era to make people feel comfortable that the new government, right, the new national government was not going to overreach. The problem with a list of rights is that there's no way we're going to be able to list everything that people are really allowed to do in their lives without governmental interference. So the people who wrote the Bill of Rights, which was the first Congress, tried to hit the high points, right, and to address some of the things, some of the grievances that they had with the form of government, right, the monarchy, under which the United States, or under which America was operating, right, the colonies were operating before the Declaration of Independence. So they hit the high points. Now, if you're making a list, those who study constitutional law are familiar with a saying, right, and so some of you obviously are familiar with the saying expressio unius est exclusio ulterius, which is a fancy Latin maxim, which means that in a legal document, when you start building lists, you better be careful because you're going to be stuck to the list, right? So the people who wrote the Bill of Rights knew we're in dangerous territory here, because if we were at 8 amendments, right, that list rights that people have, then future courts are going to assume, right, that there is no other right other than those that we listed. If we have a list of them, then we're stuck with the list. This makes sense. If you think about your own life, again, the expressio unius rule makes sense, and again, it applies not just to the Constitution, but other legal documents as well. If I'm renting a place and my landlord says, here are seven things you're responsible to do, right, in terms of maintaining the property, and then comes after me and tries to evict me for doing an 8th thing that's not in our lease, right, what's a judge going to say? No, you're stuck with you have a list here of things, right, you're stuck to the list, that's what you agreed to. So we're going to play that game with the U.S. Constitution and a Bill of Rights. Then obviously we're inviting future courts, right, future judges to say, nope, if it ain't on the list, it ain't on the list. So, by the way, expressio unius est exclusio ulterius, the expression of one thing is the exclusion of others, right? That's the Latin for. But again, that's just fancy for if it ain't on the list, it ain't on the list, right? Now, to deal with that problem, the first Congress, right, the people who wrote the Bill of Rights included the 9th Amendment. The 9th Amendment undoes the expressio unius rule, right? The 9th Amendment clearly says that as to this list, right, as to the Bill of Rights, this list and the way it's worded, right, the enumeration in the Constitution of certain rights should not be, right, construed as denying others, and look at this word, retained by the people. What? Retained by the people. This is why I say you can't understand the 9th Amendment without a little bit of Locke. You got to understand what this means. Right? This reflects an understanding that there is certain power that people would cede to government, and that the rest is retained by the people and need not be enumerated in a constitution to be protected. So the 9th Amendment, when somebody argues, right, there is no right to marriage in the Constitution. There is no right of a parent to raise their own kids in the Constitution. There is no right for families to make their own decisions, who their other family members who are in their household. The Constitution doesn't say anything about that, right? Constitution doesn't say anything about contraception, right? And of course, the big one, the Constitution doesn't say anything about abortion or reproductive choice, right? There's a lot the Constitution doesn't say anything about, right? And it's a cop-out just to say that the Constitution doesn't say anything about it. And I'm not saying that any of these things should be rights or shouldn't be rights, but you can't just say that it's not a right because the Constitution doesn't mention it. To say that is ignoring the 9th Amendment, which is a clear constitutional command, right, that people's retained jurisdiction over their own lives be honored. That's why we have a body of law, right, in constitutional law, not about enumerated rights, but about unenumerated rights. Then we get to the 10th Amendment, which might be one of the most often miscited, right, or misquoted parts of the Constitution, and I fear that sometimes the failure to accurately state what the 10th Amendment says is intentional. The 10th Amendment says that any power not given to the federal government, right, and so there's part of it, most of that's in Article 1, Section 8, there's a part of the Constitution, speaking of lists, that contains a list of things that the national government is allowed to regulate. and the national government, the lawmaking branch is Congress, right? So they're actually stuck to a list, right? And they're and the expressio unius rule applies. Now, what the 10th Amendment says is that, right, as to anything that's not on that list of powers that is given to the the national government, all of that power is reserved. That's another word that reflects John Locke, is reserved to the states, respectively. Now, a lot of people think that there's a period right after that. There isn't. There's a comma, and the comma is followed by an or. And or is one of the most important words, right, in the law, right? Not and, but or, right? It means it's a disjunctive, right? It's one or the other. Or the people. There you go. We have it again. Okay. So, but the 9th Amendment says retained by the people, and even the 10th Amendment, which most people cite for the authority of a state, right, to act under what we call its police power. But the 10th Amendment also reflects a concern for power that is reserved neither to the federal government nor to any state government, but rather to the people. So there is a sphere of life, right, that the federal government has jurisdiction over, right, for the common good. There is the national common good. There is a sphere of life that a state has jurisdiction over for the common good, for public health, safety, and welfare. And then there is a sphere of life over which only the individual, right, has jurisdiction. So these are really important principles, and from the text of the Constitution, reflecting the philosophy of John Locke, right? It's really important principles to understand, to really get your head around, right? Why do we have these things called unenumerated rights? Why do courts go there? Courts go there because they really sort of have to, because the 9th Amendment opens that can of worms, right? What types of stuff are people supposed to be deciding for themselves? What type of stuff, right, are states allowed to regulate for the common good? And what kind of stuff is the national government allowed to regulate? That's why we have things like a right to decide who we get married to. That's why we are allowed to, competent parents have a right to raise their own kids without the government's interference. That's why it's none of the government's business, right, whether grandma lives with her 2 grandkids. Even if there's actually a case about this where a local zoning ordinance wouldn't let a grandmother live with her 2 grandkids because they were cousins rather than siblings, right? And the Supreme Court said, none of your business. That's none of your business. There's no way that kind of decision, right, about how somebody lives their life, right, or who lives with them in their family house, their family household. There's no way that anybody would cede that authority to the government. There's no reason for a state or a subdivision of a state to be regulating that under its police power. So those are the sort of divisions of jurisdiction that are reflected in the Constitution. And one more time, that's why we have unenumerated rights. That's why courts recognize unenumerated rights. And that all has also to do, of course, with the use in the Constitution of terms like liberty and privileges and immunities, right? That all of which suggest some kind of broad jurisdiction, right? That people have over their own private lives and their lives as citizens. So onward and upward after this one, but there's some fundamental underpinnings of the study of unenumerated constitutional rights.